Thank you very much. I'm going to now recognize myself for 5 minutes for a couple of questions. First off, I want to say that whistleblowers are the lifeblood of this committee. It's dedicated government employees who see something going wrong in their agency that have no recourse other than to bring it to the attention of Congress, which is the right way to do it. It's not the right thing to do the way Mr. Snowden did it and take it to another country. And we work hard, and we've passed legislation to make it safe for whistleblowers. And this committee, and I think Ranking Member Cummings will agree with me, will bend over backwards to protect a legitimate whistleblower. In fact, the committee website, oversight.house.gov, has a place you can go online to become a whistleblower. And I guess there might be a lesson in this for potential whistleblowers. Maybe the initial contact needs to be made from your home computer or a computer at the library or from a Starbucks. But you shouldn't be afraid to use your government computer to report government problems. And Mr. Harris, I know a lot of this happened before you got there, but you are the acting chief information officer. So I want to take a step back and maybe look at what should have been done. I mean, I understand the our computer, our rule mentality. In the private sector, you've got a lot more flexibility than you do in the public sector. The Constitution doesn't apply you due process in your private sector job. In many private sectors, there are no whistleblower statutes other than potentially to the government. So you got a lot more, as a manager, you got a lot more options in the private sector. But in the public sector, going in and installing snooping software seems rather draconian. I would think good practice is to have something on your network that captures all incoming and outgoing mail, and then you have the ability to search that after the fact if you've got a leak. And I'm going to talk in real. I've used Encase before. That's a forensic software that lets you go copy somebody's computer. But nowadays, with all compliance issues in various industries, there are appliances that you can put on your network that catches all the mail and saves it. And you ought to be able to search that for emails to the New York Times and have an exclusion saying, if it's mail.house.gov, don't show me that. I mean, it seems like it's that simple. Didn't you all hire a contractor back there? Couldn't you have told the contractor when pulling the Encase stuff, if it says mail.house.gov, I don't want to see it?
Yeah, I think you're on the right track. I think one thing we should note is that monitoring is actually rare. And I think what sews this together is when you think about the reasons we do monitor it at times, I can give you a couple of instances. I mean, we have had cases of child pornography. In my mind, we should immediately act on that, and we should immediately start to look for the issues there because the child's life is in the balance here. And then there are other instances where insider trading does become an issue to protect trade secrets. But, everyone is correct. The need to protect those who whistleblow is important. So this new process that we have in place does that. It has, again, on the committee, a legal individual, someone from IT, someone from HR to consider the entire range of issues that we may face before we even initiate a monitoring process.
It's just hard to judge what the culture of that is. If within your agency there's a culture of gossip, does it slip out? You've got to deal with the human elements of that as well, and I do think there needs to be a technological solution to that. Let me go to Ms. Canterbury and get her thoughts on what the appropriate way to do this is.
So first I'd like to ask why on earth the FDA would conduct surveillance if they had suspected child pornography or insider trading occurring. Why would they not go to the FBI? That just makes no sense to me. So I'm struggling with under what circumstances.
You run into. I've run a computer consulting company. I've done this for private sector. You've got an employee you think is. Let's take child pornography out of it and is just surfing porn, and that's against your policy. They haven't broken the law, but they've broken your policy. So I mean, obviously there are cases where you need to do that.
Sure. And so in that case, my question would be, on the back end of the review committee, I think is a substantial structural reform. but it's only reviewing, to my knowledge, according to your interim policy on the front end. So what would be an improvement would be to do a similar review on the back end, because there's no way you can use enough search terms to protect public whistleblowing. So if an employee is blowing the whistle with non-legally protected information to the New York Times or to the Project on Government Oversight, that also cannot be swept up, or they've been in violation of the Whistleblower Protection Act.
And I'm going to agree with you that in many cases retrospective is the way to go. I'm about out of time, but I will give Mr. Harris an opportunity to respond before we go to the gentlelady from California.
Let me be clear. We by no stretch of the imagination are coming here today to tell you that our process is 100% perfect. The idea behind this is to have a methodical approach to this. And by the way, the FBI come to us sometimes for referrals to do some of the work that we do. And so it is by nowhere near perfect, but the only way the agency can move forward is to start something now, and then we perfect it to a point where we can then spread it to the rest of the agency, and then we all understand what our policies, rules of engagement are around monitoring.
All right, thank you very much. I appreciate your indulgence. We now recognize the gentlelady from California.